It's may please your lordship.
So in
No. This is a matter where Gopal Subramania, my friend, was appearing on the other side. That 1400 crore matter. Your lordship directed to be listed on the 7th, and it was
what's the matter?
the 1400 crores, Malas, where the award, Malas, 1400 crore, the 36% interest, Malas. Your lordship, now your lordships had directed it to be listed on the week commencing 7th. It was shown for the 8th, but suddenly it disappeared overnight, Malas. Would my lords be then fix it?
Lordship may have it after 2 weeks. I'm
Why
appearing
2 weeks? Why 2 weeks?
Lordship, next week, Mr. Subramaniam is in some difficulty.
But this is
2
not.
weeks.
You just move a slip. I'll just ask them to fix it.
Yeah.
Why was it removed?
Malas, just shocking, Malas. It is, but it is, Malas.
It does. Unless it will be listed accordingly.
Deeply obliged, Malas. Let it come up any time.
With your lordship, most gracious permission, my lord.
Yes.
Your lordship would ask why you are mentioning, because otherwise the registrar will lodge it.
No.
My lord, now, my lord,
Don't
5
start.
times the former Chief Justice said, we'll constitute a bench, but it was never listed, the registrar.
What direction are you going? Please tell us.
No, my lord, NJSC matter, my lord, it has to be
Please take the
revisited.
slip, we'll take it up.
No, my lord.
I have sent a email, my lords.
It will be all taken up. It will be all taken up.
Just flagging it. This is the West Bengal teachers matter, my lords. Your lordships have terminated all of them.
Please.
We have administrative difficulties, which we had said.
Pardon,
The board.
Pardon, please.
Huh.
We have said so many times, and I'm repeating it infinitum now.
Please, my lords.
Repeatedly every day. Any mentioning, just move a slip, it is taken up the same very day. If it is done afternoon, it is taken up the next day.
Please, my lords.
That's
We had
If
sent
you do it
yesterday.
by 10 o'clock in the morning, it comes before me at 1 or at 2
We sent
o'clock.
it last night also.
Same day. If you've done it last night, it will come up before me at the after lunch.
No, we agree that, my lord.
What
We are
else can
obliged.
be
No.
Your lordship has
The
done that.
request is
Lord.
for tomorrow.
But only difficulty is,
Whatever is possible.
Please, my lord.
That don't insist. We have to.
No, I know. I'm
my lord, your
just
lordship
flagging.
has done it, my lord. We are
Next
greatly
case,
obliged. Only
sorry.
thing is, my lord, we need a specific date. We need a specific date.
Error in an
My
order.
lords, I am the petitioner in person in this NJSC case, my lord.
In?
My lord, this has been dismissed by the registrar. It has been lodged. We had filed.
What is NJAC case? What is NJAC?
No, my lord, we are seeking a revisiting of the NJSC case. And my lord,
Let's move a mentioning slip.
and give us a date, my lord.
No, please, sorry, nothing like that. I've told you, please move a mentioning slip.
And we are done, already done.
That's
And
will
the
be taken
parking
up.
persons are waiting
No,
outside.
please, do not do this. We have ensured that no mentioning is done. Otherwise, at least 15-20 minutes in the morning are taken up with this. Stop it.
Yes, my lord, yes.
My lord, this is the case about the non-arbitrability of mortgage. My lord, since we had been protected since 2013, my lords had deemed it fit to continue the protection for 6 months.
No, sorry.
My lords,
Sorry.
Matter. So I believe what was said was 6 months.
my lords, in the while my lords, I'll
may
give
I-
a context.
We
My
had
lords-
said 6 weeks.
May,
My lords, with the utmost, sorry.
Sorry, even if it was stated 6 months, what I meant was 6 weeks.
My lords, then can I request one thing? My lords, could it be 7 weeks in that case because a week has passed? My lords, the summer vacations are also coming
No,
up.
doesn't.
My lords,
Summer vacations are still far off.
My lords, the only difficulty
Sorry,
is to hear the matter.
Sorry,
To get a stay.
sorry,
Have been protected since 2013, my lords, when the arbitral award was passed.
So if you are agreeing it's 6 months, then we.
Bhaiya is online.
My lords, we,
my lords,
Yeah, I was very clear. I was giving 6 weeks, which is more than sufficient.
my lords, I may be at Mr. Puvaiya's mercy right now, but we
Yes.
heard.
Did I communicate 6 months or 6 weeks?
my lords, let me clarify that, my lords. I had said 6 months. Your lordships had said 6 weeks. So it is correct that I had said 6 months. That much I must be clear, my lords.
My lords, in that case, could it be
Sorry.
extended by
No,
1 week?
no,
my
no,
lords? It's a
sorry.
humble request, my lords. Doing within a few weeks, my lords.
How much time does it take you to draft a
My lords,
petition?
I understand.
Please,
Just
that's
for the
it.
stay, my lords, because
That is a, please, that is.
obliged, my lords.
My lords, may I mention, I 45 listed today, I had mentioned yesterday as well, my lords, the London Council is not available.
Which matter?
Item 45, your lordship.
When it's come up.
We have complied with your lordship's order, Malas. We can file it next year. Maintained. And we'll file the affidavit, my lords. We have an affidavit on record. my
Right
lords.
of, in view of the order passed, it is stated that the order passed by us on. Copy of the order is not. When we passed the order,
My lords, you'll-
4th April
Yes,
2025.
No, order dated 3rd April.
3rd April. No, our order.
Friday. 4th April. 4th April. Yes.
Order date passed by 4th April 2025 has been complied.
We can place an affidavit on record in compliance, my lords, so that it's on record.
Complied, hence, this present specially petition is rendered in purchase and is disposed of.
Deeply obliged.
Yes, please.
Lordship, in item 42, I appear for Roche. I'm requesting for a passover. Lordship had on the last occasion issued notice.
Call the council.
I will.
2 o'clock.
2 o'clock,
Because all matters take, pass-through matters are taken up at 2 o'clock.
I'll call. Much obliged.
My lords, in this matter, my lords, what had happened was your lordship aggregated, my lords, the supernumerary matter from the others.
Correct. So,
My lords, we moved an application, my lords, we had moved an application to bring additional grounds on record.
1 minute, please argue on that part. Let's see what you have to say. Because we had virtually disposed of the entire matter.
Yes.
Who's appearing for the other side?
We have for the rate petitioners then.
Look, in this case, it's a cabinet decision which is taken on record. And that was taken in 2022.
That's right.
I went through the cabinet notes.
We
really can't go into all that.
Required to be seen, my lord. That cabinet decision, my lord, I'd like to read also, my lord.
Yes, let's see.
Well, the
Lordship,
19th
may
of-
Just 1 minute, please. If you require help and assistance, we'll take. Just give me that.
They wanted to, my lord.
1 minute, please.
Yes.
Just turn to that.
Can see.
Just 1 minute.
Yes.
Let me take out the file.
That cabinet decision.
And it's a small. Come to this file. You have this file, this one.
Can 6, my lord, possibly would be one of the applications, my lord.
Just give him the copy. Just take out this file.
Lord, it is in IA 87607, which was filed, my lord, day before yesterday, possibly.
No application can be filed at this stage after the matter has been disposed of.
87607.
Please come
Only
for
for
the,
purposes.
look, we have the copy of the minutes.
Yeah.
Dated 5th of May 2022.
Yes, that's the
Correct? That's a cabinet memorandum.
Right. On that basis, my lord, an application is made. On that-
But I'm not concerned. I'm just going to the cabinet memorandum. If you have that, please take us.
Yes.
And how do we get into all this? Keeping in mind the constitutional provisions that aid and advice given by the Council of Ministers cannot be inquired into and gone into by the court.
My lord, can we take up the cabinet discussion? That is very important. 5th of May 2022.
Whatever it is, please, yes.
Yes. Now that,
Can we go into examine that?
If there is an illegality, my lord, your
No,
lordship.
please. That is not an illegality. There is a note prepared. It's a decision taken by the cabinet. And normally, we do not go into that. There are restrictions starting from the earlier There are a number of judgments dealing with it. Even Kishanand Bharti deals with it to that extent. We need not go into all that. Their facts are stated. At that time in 2022, there were two views being floated around. There were certain irregularities noticed. Then cabinet decided that let's take supernumerary posts.
Whether cabinet could decide,
Please, we will not be able to, we will not step into that question.
No, but I am not on the wisdom. I am on the question of constitutionality.
Though, or even on constitutionality,
If the
1 minute please, constitutionality aspect we have already decided and struck down that.
Yes.
Now the question is whether the cabinet decision in this case should be referred to or made subject matter of CBI investigation. It's a decision taken by the cabinet as a whole.
Yes.
On the aid and advice they have given, then the matter went to the governor. The governor has issued the order.
Right.
160
My lord is probably
Sorry, we're not.
asking the question about the CBI investigation.
That's all.
If
That's
that-
only limited as it.
Now
And what is the reasoning given by the High Court is also
That's very.
not really, not,
Para 257.
I've gone through that. It doesn't really, just,
when the CBI investigation is called
I've
for,
seen that it doesn't go into all those aspects.
Para 257 only. In fact, they were all illegal appointments, my lord. And that.
1 minute, please. That's not the issue before the cabinet.
No, that is firstly.
No, Mr. Barinder Singh, that's not the issue.
Just give me 2 minutes, my lord, in my turn, whenever your lordship want to hear.
My lord-
I'll show from the cabinet, it is founded on the,
Okay.
kindly come to the cabinet note.
cabinet,
1 minute, one person at a time after he is over.
Yes, after letting me over, I
that
only need to.
cabinet decision will not is initiated by the school service committee, holding that the post be filled up for the waiting list candidate when admittedly the list was exhausted. As per the rules, there is no existence of waiting
They
list.
had the power to relax the rules and therefore,
But they
in terms
don't-
of that, they exercise.
Because they don't have the power below to create posts like
Okay.
that. Kindly comes to statutory rules once. Excuse me. I know without the limitation of the constitutional court, so far the directing investigation is concerned. But if the court's conscience is satisfied, which is satisfied in either matter, this is absolutely per se illegal, unconstitutional. Here also, the cabinet memo was prepared only to ensure that the illegal appointees are protected. Whether the rules permit the state to create supernumerary posts.
For illegal appointments.
Because the concept of supernumerary means, you are well aware, in a cadre service where the number is fixed, if someone else by chance is there, but he is of the cadre, then by a supernumerary post, that job percentage is not secured. But here the supernumerary post to create a vacant post for the purpose of fresh recruitment. Whether that is as per the rules or whether constitution permits.
Do you realize the consequences of your argument?
Hopefully so.
And- Sorry.
Only
1 minute, please, let him
If-
be over.
if-
We'll hear you, Mr. Barinder Singh.
I will wait.
Because the vacancies are to be created but should be kept
Okay,
open
we have
for all. That is
understood.
Article
We have
14.
understood. We have understood. Yes,
Your lordship may kindly see, my lord, para 257 of the impugned judgment.
yes, please.
Because this, my lord, supernumerary post, my lord, should be read in inverted commas. I'll make good the argument, my lord. Your lordship may see, my lord, how the learned division bench, my lord, they read about the role of the state government.
Yes.
Para 257. The role of the state government in the writ petitions and the appeals that have been heard by us has to be taken into consideration. As has been noted before, SSC file CAN 6, and I will read this CAN for your lordship's kind consideration, in writ petition number so and so, my lord. SSC, that is the commission,
Correct.
had prayed for creation of supernumerary posts, very good till this extent, in respect of appointments given illegally. And this is the part of CAN 6. And I will read the paragraph of an affidavit sworn by the Assistant Secretary of the Commission, which says that the supernumerary posts are for illegal appointments. I'll read that paragraph, CAN 6. State government has not opposed such a prayer. In fact, documents placed on record suggest that the state government at the level of the cabinet had approved creation of the supernumerary post to accommodate the persons who had received employment illegally, and that is the word used in the application, in the set selection process. The principal secretary had appeared before the learned single judge and produced a cabinet note. Now, your lordship may kindly see page 265, para 265.
Yes.
May I read paragraph?
Yes.
The state government therefore has accepted that there were widespread illegalities in the selection process and that the number of persons who had received appointments illegally could not be determined with exactitude. They had resolved to create supernumerary posts to accommodate the illegal appointees.
Look, this discloses the reason. What happened was, there were certain candidates who were found to be tainted. On that, there was no difficulty. They themselves had removed them or even shunted them out without following the inquiry procedure. One. Number two, they were with the, at that time in 2022, they were of the view that we cannot now segregate who are the other tainted candidates. So in order to benefit the people who are on the waiting list, they said, let's create the please, do not interrupt like
Yes,
this.
sir.
They created the supernumerary, they decided to create a supernumerary post, and the cabinet decision also says in the end, this is subject to the writ petitions already pending in the court.
Correct.
If that is so, how can you say that
The reason may not.
articles of the 74(1) and 74(2) and 163(3), we'll have to examine all that. Please answer this if you have.
Yes, I would, Milord. I just read, Milord, para 6 of Can 6, which is filed, Milord.
Yes, please. Which page?
Milord, it is in Can 6, Milord, it would be paragraph 5, Milord, because your lordship.
Can 6 is what?
Can 6, Milord, is an application on the basis of the cabinet decision.
That's a case for cabinet decision?
Correct.
Dated 5th of May 2022?
Then they swore an affidavit to this extent on 27th of September 2020.
Which portion of that?
Yes, Milord. Now, your lordship may kindly see, Milord, if they want to come clean, then para 6 should not have been incorporated in this.
Yes.
In such circumstances, may I read para 6?
Yes.
In such circumstances,
Where?
para 6, Milord, of the application.
No, don't read your application. Read the cabinet notice.
No, I would, Milord, but on the basis of this,
Okay, fine.
Yeah, the application is preferred before the Honorable Court, Milord. So the application is filed on 27th of September and para 6 is relevant.
Paragraph 6. Yes.
Milord,
607.
Yes.
Paragraph 6 begins.
para 6 at
Your application
page 13,
states
Milord.
that such discrepancies and illegalities.
Page 13, Milord.
Yes.
Milord, may I read, Milord?
Yes.
In such circumstances, it is humbly proposed, your lordships have it, Milord, that apart from giving recommendation and appointment to genuine candidates as observed by this Honorable Court in other similar matters, supernumerary posts to be also created to accommodate those,
This is
if
wrong.
any, whose
This is
appointment.
wrong. This is absolutely wrong. This is not what the cabinet decision
Milord,
is.
this is what
No, this is not what the cabinet.
Milord,
That's
who swears the
what we
affidavit?
understood.
Milord,
Just come to the cabinet decision.
I got, Milord.
Come to the note. What's the cabinet note?
Page 15, Milord, it is sworn
Just
by the
1 minute,
Assistant
please.
Secretary
I-
of the Commission.
I have said this is wrong. If this was a purpose, it is wrong. Just come to the page number 4 of the cabinet decision.
Cabinet.
Of a cabinet note.
Yes.
That was triggered by SSC.
Please, you have argued. Do not interrupt now.
When I am not interrupting, I shall argue again.
So
So,
you will
Milord,
intervene at your time, not at somebody else's time.
Milord, today, Milord, your lordship.
That
say,
the
Milord,
state government may be permitted to issue, just come to page number 4, paragraph number 3B.
the state government. May I read, Milord? The state government may be permitted to issue necessary direction to the Commission by invoking Section 19 of the Act and to the West Bengal Board of Secondary Education in the interest of education in terms of Rule 3.2 of the Education Appointment So-and-so Rules 2018 for absorption of such waitlisted candidates in the proposed supernumerary post to be created with the approval of the Cabinet. However, the same shall be subject to outcome of pending litigations before the Honorable Court.
Correct. So that was the object. And that's a reason why they have done it. And if you turn to the cabinet decision also, which has been
With
communicated.
great respect, Milord, there is no application filed that waitlisted candidates, Milord,
Sorry,
should
please.
be accommodated,
Sorry.
Milord.
Yes, Mr.
And today only one submission.
That's all, please.
Only
That's
half
no,
a
please.
minute.
That's over.
Today, your lordship.
So please, you have argued. Yes, Mr. Manindra Singh.
Lord, first submission. Lord, even the Lord, the legislative power or by power by the cabinet, Lord, on any issue, which, Lord, is founded on illegality noted in the note itself, then that is a colorable exercise of power. That is complete absence of any bona fide, and the immunity and protection to the cabinet decision making, my lord, will not come into play. Kindly come to that cabinet note, the second para, para 2.
Yes.
If, my lord, if
Mr. Manendra Singh, you are paying for whom?
my lord, for the writ, petitioner, respond number 1, my lord.
Did you make that prayer in the writ petition? Did you make that prayer in the writ
This
petition?
has come during the proceeding.
No, please. Did you make that prayer in the writ petition? You should have amended the writ petition.
My lord, kindly see, my lord.
Mr. Manendra Singh, answer the question. Did you make that prayer in the writ petition? Yes or no?
At that time, it was not even.
Okay, fine. That we take it that the reason you're not answering it either way is you did not make.
Yes, my lord, it was. Now, may I just show that paragraph, my lord, to your lordship?
Okay, fine. Now the second argument. Can such a prayer or issue be?
That's what I'm answering, my lord. If, not just by 1 minute, my lord, your lordships have read the note, your lordships are asking me to read the note, only one paragraph.
Yes.
It is not, my lord, with utmost respect, not simple, my lord. There is a distinction, there is a bifurcation of a bona fide decision making and a decision making which is colorable. Now, my lord, the note itself is founded on the basis that there are appointments which are not in any list. Kindly have a look at para 2.
They are not defending those appointments.
Not on appointment, my lord. If it says, the commissioner says, these appointments are required to be cancelled. They are out of no list. Kindly permit me to read 4 lines. The chairman, West Bengal Central, my lord, I am para 2, subclause 1.
Yes.
Subclause 1, my lord, and kindly come to subclause that unnumbered para. Can I read it? The chairman, West Bengal Central Service Commission, further later dated, placed a report to the state government stating that there are 751 who are not in any list, either in panel or in wait list. The West Bengal Board of Secondary Education has also confirmed the fact of such appointment of non-teaching staff beyond the list as reported by the commission. The chairman of the commission further stated, for teaching posts of so-and-so who do not feature in any list, either in panel or in wait list, should be cancelled by the commission. Now, my lord, this is not one of the views. This is a factual position of illegality.
Recommending cancellation.
No, my lord, kindly this.
What else do you require, Mr. Manendra Singh?
My lord, my lord, please, my lord, visualize the situation that blatant illegality is noticed.
They are not condoning that.
No, my lord.
They're not asking you to condone that. They're not asking that it should be overlooked. All that they're saying is, now that the panel list is over, everything is over, we cannot now carry out further investigation. So let's accommodate the people on the waiting list so that they can be also given.
My lord, your lordship, 1 second, my lord.
That was the objective.
1 second. If, my lord,
how can you attach criminality to it? I don't know.
Just 1 second, your lordship would permit me, my lord.
Is it so simple? Cabinet decision being.
My lord, if a cabinet decision note is.
You have argued that. Mr.
No, I'm
only saying factually this is not flowing from that.
No, this is that there is a report, there is a letter. There is a report that this illegal admission must be cancelled. Lord, on this, the CAN 6 is filed. Lord, with utmost respect, if supposing the illegality is at the bottom of any decision making, admittedly, there is no dispute on this, that these appointments are illegally made from no list.
Okay, that understood. You have to want to add anything, Mr.
Appointments have been made. I don't know what my learned friend is.
Only one slide on.
Only one submission.
With pilot's permission.
I have filed an IEA in connection with only one this matter.
The matter is over.
Kindly pardon us. We are not covered by this recruitment process. We are not teachers who were appointed.
You are nobody then, please your listeners like.
Work education, physical education teachers not covered by this.
Okay, fine. Mr. Sybil, you want to add anything to what?
No appointments have been made under this court because of those
right
in the wait list.
My lord will.
Just this now. Let us take on. Pursuant to our decision.
And under 163, your lordship is aware.
In terms of our decision from judgment, in terms of our judgment dated 3rd April 2025, white paragraph 52, which white paragraph 52 had held, observe that the issue with regard to direction of investigation by the Central Bureau of Investigation is a decision to create supernumerary posts will be dealt with separately. We have heard learned counsel for the parties to stop. Next slide. In particular, our attention is drawn to paragraphs 257 and 265 of the impugned judgment. Full stop. Next page. We have considered the amendments made, the observations made in the said paragraphs. Full stop. On a pointed question, it is accepted that the writ petition, in the writ petition, no specific prayer.
Hello, now you can see me here.
The cabinet decision, with the cabinet decision dated
Yes, you can.
19/5/2022, consequent to cabinet decision, consequent to which order dated 19/5/2022 was issued by the government of West Bengal after approval by the governor, was specifically challenged. Full stop. Neither was any prayer made that this order should be made subject matter of any investigation by the police or the Central Bureau of Investigation. Full stop. Next page. A perusal of the note dated, next page, 5th May 2022, which makes out the case for cabinet decision, would records that the power under section 19 of the West Bengal School Service Commission Act 1997 is being issued, may be issued in respect of waitlisted candidates, but the same shall be subject to the outcome of the pending litigation within before the High Court of Calcutta. Stop. The cabinet note, the case for cabinet and the cabinet decision was taken at the time, which is accepted when there was there were pending litigations in the High Court, and the possibility of finding out by thorough examination the list of tainted candidates was not possible. So stop. It is pertinent to note that the case for cabinet note, decision dated 5th May 2022, specifically mentions the view expressed by the Central School Service Commission that they were wrongly appointed candidates by way of rank jumping, etc. Nothing was hidden. Full stop. Next paragraph. Having regard to the aforesaid facts, having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary posts pursuant to the cabinet decision to investigation by the Central Bureau of Investigation. Just record one more thing. It may be relevant here to reproduce, to take note of clause 2 to Article 74 and clause 3 to Article 163, which specifically states that the question whether any, and if so what, advice was tendered by the Council of Ministers with the Prime Minister as his aide, to aid and advice of the President. Stroke. Advice was rendered by the council, by the ministers to the governor, comma, shall not be inquired into in any court. Full stop. The aforesaid direction is therefore set aside and quashed.
It is only with respect to the investigation.
Pardon?
My thought is only watching the part of investigation.
Pardon?
Watching the part of direction.
No, that's fine. That's fine.
Nothing, but so for the pending matters are.
No, we are not touching.
Yes.
We clarify that the directions, that our observations and directions given in this order are limited to the extent of the direction for investigation into creation of supernumerary posts and do not in any way impinge or reflect upon the investigation and the charge sheets filed by the Central Bureau of Investigation in other cases.
And also with the.
On other aspects.
And with the pending repetition also.
Pardon?
And also it.
Obviously, the repetition stands
Well,
on
that's
its
why
own
is
merit.
my.
Record bit. I mean, otherwise it will be confused.
That's what, there is no confusion.
Very well.
Deeply obliged, boss. Deeply obliged.
Gone and forgotten now. Great case.
Only to, I see it, my lord, but only two couple of things. The exposition which is being put on the petitioner, my lord, in the impugned order. The entire.
I don't know whether correct or not.
No.
The judges of that court know what you went.
That's why I can show it from the writ petition. Whatever he had alleged were based on the RTI responses which he had received, number one. Number two.
After 11 years.
No, not exactly. No, that 2011 is the FIR itself. Just wanted to show.
I just leave it.
It's 2006.
Are you a political person?
Yes. And it's been disclosed in the writ petition. I did not.
Okay, then the query answer is also.
Only one observation. There is an FIR which is going.
We are not
pending.
saying anything more. We are not inclined to interfere with the impugned judgment and then specially petition is dismissed. Next case.
But though that impugned is in the nature of an intent.
So, you've been punished?
Blood of Lordship only dispose of this petition with direction. Both the petitions are pending.
Which petitions against your inquiry result?
Against my dismissal and presently
The present specially petition is rendered infructuous, as it is pointed out that the disciplinary procedure have culminated into an order of dismissal, which is under challenge before the High Court.
That is pending.
In view of the opposed factual position, the present specially petition is dismissed as infructuous. We clarify that the impugned judgment and the order passed dismissing the specially petition as infructuous will not have any bearing on will not have any bearing or effect on the writ petitions pending challenging the order of dismissal.
all the questions may be open to me.
All questions are left open.
Great. To be laid before the High Court.
All pleas and contentions will be examined by the High Court.
Okay.
In the writ.
Grateful.
Lord, the High Court has decided this petition beyond the relief.
What happened to your second appeal?
That second appeal is pending. In fact, it has been clubbed with the suit. There is also a suit filed by us, my lord, because for the construction.
Order is correct. How can you build on a water body?
May I tell your lordship, we are not made parties. The relief sought is decide our representation. The High Court says no, as if on the assumption that we have actually covered the pond.
You have?
No.
What else?
No. Kindly see. There are orders in our favor. Lord, they suppressed the.
What is the position now? Is the civil suit pending?
That civil suit, my lord, is for
Lord, before my-
compensation. He is praying for release of compensation for part of the land acquired belonging to the temple, my lords. That has nothing to do with second appeal. That has been dismissed.
The second appeal has been
Madras
struck with that.
Sangi, please wait for your turn. Let us make a statement.
Yes.
We found something merit in your contention, therefore we ask the other side.
I'm sorry.
That civil suit has been dismissed. It has not been restored. Yesterday, I checked the website
No,
of
but
Madras
no,
High Court, my lord. Second appeal.
This order cannot be passed without hearing a person.
My lords, may I then only invite my lord's attention to 78 HR and Act and
What
they
may-
leave
one,
it to that.
no, please.
Joint
You can't-
Commissioner suo motu has power to initiate action.
But maybe,
against process, my lord.
maybe, but that doesn't mean that the writ court exercises that power. Cannot step into the shoes of the commissioner. And commissioner also may have so motu powers. The commissioner also will give a notice to the other side before it takes.
Let then my lords may
We are just simply, we'll simply set aside this order
Back, let us be parties, my lord. That's all.
and let them appear and do whatever they want.
Let it be decided.
That it cannot be done ex parte.
Then direct the High Court to hear them and pass. on.
Correct? Obviously. What else am I saying? I'm not saying anything.
Lordship may direct our impediment, my lord.
Right now.
We'll file a counter.
Respondent number 2, the Commissioner, my lord.
You agree with that or you want to contest that?
They are hand in glove, my lord. That is my
No, very
submission.
special.
Because they have not taken.
You are there,
action.
you are there to check them.
They don't do
Right
that.
on.
That's why I'm before court, my lord.
Right on, leave granted. We are inclined to set aside the impugned order without examining the merits of the contention. Merits of the contentions raised by both sides, as it is accepted that the directions given in the impugned judgment dated 18/6/2018 was passed without hearing the present appellant, namely so and so. Stop. Next page. Accordingly, we allow the present appeal and set aside the impugned judgment dated 18/6/2018 with an order of remand to the High Court to decide the writ petition number 14031 of 2018 afresh without being influenced by the earlier order.
After
So
repeating us as parties, my lord.
the respondent, the appellant so will be implemented as a respondent to the said petition by the writ petitioner. Stop.
Your Lordship,
Cut short delay.
it will say.
Will be implemented as respondent to the said writ petition. Full stop. Amended memo of parties will be filed by the writ petitioner, who is the respondent before us. Respondent number 1 before us within 10 days. Next page. To cut short delay, parties are directed to appear before the High Court on
Lord, may I say? Your Lordship,
14th of May 2025.
In the meantime, let us file our counter, my
Lord. 14th of May 2025, and the date of hearing will be fixed. It's not. It will be open to the present, to the applicant before us to file his counter affidavit within 6 weeks from today.
May I make a humble
14th
submission,
May,
my
I'm
lords?
informed, my lord, the courts may be closed for summer vacation.
When is it reopening? When is
June,
it
my lords,
closing?
the month of May.
No. From May 1st, it is closed. Your Lordship may fix it in June sometime, my lord, because
Okay.
May probably is closed.
Okay. On 3rd of June,
I have a humble submission on the order, my lords. Today, what is?
the interim order, once the order is satisfied, there is no interim order required also.
Not at all, my lords. I'm making a different submission, my lords. The appellant's son has now become the hereditary trustee. So, my lord, instead of appellant, may say the hereditary trustee of the temple, my lord.
Yes.
Because there is a
That,
change.
we
in
have also
status.
moved an application for that purpose.
Okay, the appellant stroke hereditary trustee.
Trustee, yes.
Yes.
So you give the name of the appellant stroke hereditary trustee.
In fact, my lord, our application for a substitution.
For substitution, that has to be allowed. Okay, then application first you say application for substitution of the appellant is allowed. And then you say in the later portion of the order, we have given the name of the appellant. Give the name of the appellant as given in that application for substitution.
Grateful.
Great.
That's item 4, I appear for the petitioner, Lord. Madam, the decision to change the location of this ITI college from village Ticker.
Now it is already constructed, everything is done.
I am,
And 27 trees were cut.
Lord, Lordship has.
You also came in after a long time, after 1.5 years.
What I have been informed is that perhaps it has not been completed and constructed.
No,
Because
no,
thereafter
no.
also, Lord, the government changed.
22, they filed an affidavit, it's constructed.
20, yeah, they said that it will be completed in 22, but.
But you came in much later, by that time trees had already been cut.
Lord, as per the earlier procedure.
We are, in view of the counter affidavit filed, we are not inclined to proceed further in the matter, and hence the special petition is dismissed.
Get
There's no counter affidavit filed in this matter, Your Lordship.
1
Notice was
minute,
issued.
please. 1 minute, please. Who's appearing for the content? It's very simple. Served?
Yes.
And what has happened is the illegal construction there,
The construction has already been completed.
so somebody is staying there. And is there any regularization scheme?
Yes, Your Lordship. All those documents we have already provided to the authorities.
Is there any regularization scheme? So leave granted. One appears for the respondent despite service. They have proceeded ex parte. Next page. The impugn judgment dismisses the contempt application filed by the appellant for alleged defiance and willful disobedience of the order dated 13/9/2020. 3/9/2020, passed in petition number 14662 of 2020. Titled so and so. Page number, that order is at page number 15.
15 to 19.
So stop. Next page. The contempt petition was dismissed on the ground that it is barred by limitation as per the period prescribed under section 20 of the Contempts of Court Act 1961. Full stop. The short argument B of the appellant is that that the court lost sight of the order passed by this court, holding that the period between 15/3/2020 to 28/2/2022 should be excluded in view of COVID-19 pandemic. Stop. Next page. That being the position, we have the view that the impugned judgment is not sustainable. Stop. Accordingly, we set aside the impugned judgment and direct that the contempt petition may be heard on merits. Stop. We have clarified, we have not recorded any observation on filing on merits, or even on the question whether or not the contempt petition would be maintainable. Stop. The appeal is allowed and disposed of in the above terms. With an order of remand. Stop. We clarify, this order should not be read as expressing any opinion on merits. All pleas and temptations are lifted. Next case.
I'm grateful.
Item 6.
Have you paid the money or no?